Actually, so not like this back camera like that. Like my lens dirty or something. I ain't sure. To the one viewer, don't judge me. I'm trying to get my lens together. All right, y'all. So I cannot see who is in the chat with me, but you can put something in the chat and I'll know you're here. Now, I don't normally go live on YouTube, so this is very different for me. Y'all gonna have to bear with me today. I'm trying to find my footing with YouTube. For one, because the whole recording thing is different here. I have to I was trying to show y'all examples. I want to talk about contracts and how they are relative to debt collection, and also stress the importance of being able to identify if a contract is legally enforceable, because you wouldn't pay a balance on something that they can't pursue in court, right? So the only way to know if they can or cannot pursue it is to know if it's legally enforceable by being able to recognize that. So I kind of wanted to talk about that. That was the whole purpose of me turning this phone around so I could see that screen. But I need to know who's in the room with me, and for some reason I can't see that. I hate that for me. Okay, we'll do it like this then. Since I can't see who's in the room, I'm gonna post a note. And I would like you guys to drop something in the chat as you come in. That way I know who I'm talking to and that somebody is in here for me to talk to. All right, so let's talk about debt collection. When somebody is, so I was sitting here going over a lawsuit. One of my followers on TikTok is being sued by, who is this? Scott and okay. So allegedly, Portfolio Recovery is suing her through Scott and Associates, which is also, they are also registered as a debt collector. So we have, I just want y'all to see how this breaks down. So the contract is what is at stake here, right? Now, for it to start off, the contract starts off between you and the original creditor. So we got you, the original creditor, and then the original creditor in this situation was Synchrony Bank. This person had a Lowe's credit card. All right. So the original creditor is the bank. Um, when this was charged off from the original creditor, from their records, portfolio recovery was assigned the debt. So it went from the original creditor to the debt collector, who was portfolio recovery. Now, on this paperwork that I'm showing, she received a letter from Scott and Associates. Now I'm gonna pause here because Scott and Associates are also registered in Texas as third party debt collectors. Now, that basically means that they can collect, and more than likely they do collect on debt for original creditors, and they also sue on behalf of original creditors. This is where it gets a little greasy because some debt collectors who are also lawyers can intimidate people just by their status. Like, imagine if somebody was a doctor and they were telling you not to eat a certain food, you would be more inclined to believe them because of their status, right? So if a lawyer comes to you and say, this person hired me to collect this, you automatically think they hired them to sue you, right? The logical thing would be to think you were hired to sue me. They hired you to sue me. Because most people hire attorneys to take care or to handle their legal business. So we're gonna assume that the average person is gonna assume that they hired them to sue them. And then you're gonna be like, well, what could I do to make this lawsuit go away? How could I settle? Because the average person says, how do I make this go away? How do I settle? To settle means you're going to agree that you owed something and you're taking accountability and paying that, whether it's the entire balance or whether it's 10% of it. You agreeing to pay something is you settling. Is settling good? Sometimes people have an incentive to settle because of what they may be trying to do in life at the time. Sometimes you have an incentive to fight because you're not pressed for time. You're not trying to get approved for nothing right now. You have time to fight with these people. You got time. You know, if you don't have time, then sometimes it's better to settle. Now, looking at this transaction, we have one contract that's went through these three people hands. Now, one thing we need to understand is all contracts have a SOL. This stands for Statute of Limitations. Statute of limitations go hand in hand with contracts. Why? Because contracts are governed under state law, state and federal law. But each state has a statute of limitations that says if say your statute of limitations is 3 years. Once I default on an account within this state and the statute of limitations is 3 years, 3 years from the date of the default, they have to either sue me, try to collect on the debt, report on my credit report, all of that stuff. 3 years. Now, credit reporting also is governed by FCRA, where they have a 7 year period to be able to report things on your credit report without it being penalized, without them having it to drop off or any of that stuff. So if the statute of limitations is 3 years for them to collect on a debt, but then um 3 years for them to collect on a debt, but they don't ever try to pursue that within the 3 years. At that point, if they sell it to somebody else like this person, say they had 3 years to collect on this debt, they didn't collect on it. What they did was they sold it to portfolio recovery. That does not restart the 3 years. That does not allow them 3 more years because it's gone to another party. That's called re-aging, right? So for the statute of limitations on this contract, if it's 3 years, 3 years from the date that I defaulted with this person, this contract is void. This person right here, if they receive an assignment, they're still going off of the original 3 years, even if it goes to a different agency. After the 3 years, this agency doesn't even have power to sue me anymore. Why? Because the original creditor statute of limitations has ran out. And it does not start over every time it changes hands. Does that make sense? Y'all understand? How's your Maya? So the statute of limitations does not start over when contracts change hands. All contracts have a statute of limitations that are governed and outlined by state law. And every time it switches hands, the statute of limitations does not start over unless you start a new contract. So new contracts start new statute of limitations, of course, because it's a new agreement. If you enter into an agreement with portfolio recovery to discharge this agreement, this is a new agreement. Y'all understand that? Anytime you make an agreement to settle another debt, a prior debt, a different balance for a different amount, that is a new contract. Although it may not be one that you're going to have to abide by for so many years, it is a new agreement. So then if you make that new agreement and then you default on it, the statute of limitations has started over essentially. I want to be clear on that because some people feel like um when they switch hands, they don't have to, the statute of limitations doesn't matter anymore. That's just not true. Now, hold on. All right. So at this point, we've talked about contracts, statute of limitations, how changing hands does not restart the statute of limitations, which it doesn't. Now let's talk about um, misrepresentation because this one contract that started here is now with this company, and this is the company that is suing the client for this contract. Now, their statute of limitations is 4 years. They're actually still within the statute of limitations to sue this lady. The problem is this company is misrepresenting the character, amount, or legal status of the debt to the client. How are they misrepresenting it? First of all, okay. So initially, these people say that so Scott and Associates is suing this lady for damages of 2,723 cents. I mean $23.02. Then they want court costs. The court cost was 145, which is insane. Total judgment amount. So they want 2,800. They want $2,800 from this lady. Okay, I didn't read that part. So I'm reading this lady default judgment. For one, they sued her for just the amount that they're claiming in damages and court costs. That's a little suspicious to me, and I'm gonna explain why. If I'm a third party and if I'm a third party and I'm buying an account, right? Say that some this lady owed the original creditor $2,700, 27.23 and 2 cents. If you owe that to the original creditor and I'm a third party coming in to buy something from the original creditor, if I give them this entire $2,723.02, I'm not making no profit off of this. In fact, if I also have to pay court costs to collect this, this is not really no profit. This is exactly what I would have paid to the original creditor. So what I'm thinking, because what I don't think is that they gave the original creditor this amount of money. What I think the original creditor did was discharged it. They charged it off because they had to because of accounting, and they turned around and sold this person's information to Portfolio Recovery, who then sold it to Scott and Associates. That is how I believe that happened. Um, Scott and Associates is trying to collect the exact amount that was lent to the lady plus only the court costs. Why that doesn't make sense to me. If somebody hires an attorney, do you believe that an attorney would take a case for free? Do you really believe an attorney cares that much about justice that he'll take a court case for free? Some of them do, but a case in this type of manner, like a civil case, I don't think one would do that. And then not make any money off of it. I just don't see it happening. Then you came out your own pocket with 145.16. I don't see it happening. But Scott and Associates misrepresenting them being damaged. When you say you're being damaged, that's like an injury. So if somebody injures you, they have to reimburse you. They have to pay you for the injury. If you're damaged, they have to fix your damages. They have to reimburse your damages. How would a third party be damaged this amount if they never gave the consumer this amount of money? Think about that. If a third party debt collector like Portfolio Recovery or Scott and Associates comes in and say, I want to collect this amount of money, what would give them the right to do that? Even if they were assigned the old contract, what consideration did they give? Consideration is what we both gave in return for the other person's either promise or their asset. So, what consideration would be given by these two parties to be able to claim that amount? In my opinion, I don't think they have a right to claim damages. Maybe court costs because they paid the court costs, but they don't have a right to claim damages. Why don't they have a right to claim damages? Because they were not injured in the amount of $2,723.02. They just weren't. Um, dang, wow, somebody's calling me. If you guys are enjoying this information, put something in the chat. Let me know you here. Okay. All right, y'all. 1 second, 1 second, 1 second, 1 second. I should have put my phone on D&D, but this has been a busy ass Monday. So I want to wrap up what I'm saying about contracts so you guys can understand. If someone is enforcing somebody's contract, like I was saying, the original creditor, how you have this agreement with the original creditor, how the original creditor is bonded to you through this contract, and this contract is based off of a statute of limitations. Every state sets your statute of limitations. When we get over here and start talking to third parties like Portfolio Recovery, as well as Scott and Associates, who are also debt collectors, they are all still under the same statute of limitations. They're still governed by the same contract as the original creditor. Now, the original contract had to have allotted for this amount of money for the original creditor to be able to claim it. Also, for these two people to be able to claim this amount of money, you, the defendant, would need to ask, how were you injured in this amount? Not only that, how are you injured in this amount of money? Where's the assignment showing that you were assigned this account and how much money you pay for it, how much consideration you pay for it? Because imagining these people paying $10 for your account. I'm just throwing it about that. But just imagine these people paid $10 for an account that you around here about to pay $2,723.02 for. I'm just saying. Imagine that. Imagine it being bundled together with thousands of other accounts and being sold for a small handful of coins. And then they turn around. How you doing, J Mac? Welcome to the live. And then they turn around and sell it to somebody and have that person try to collect every single dime you signed that contract for. That is what's called misrepresentation. That's also prohibited by FDCPA. FDCPA is the Fair Debt Collection Practices Act. It prohibits misrepresentation of the character, amount, or legal status of any debt. So if a person is trying to collect this amount of money and they can't even prove that they have the proper standing, they can't prove that they gave any consideration, they can't prove that they're a party to the actual contract, then you can find them in violation of FDCPA and get possibly $1,000 per violation. So every time you catch these people violating the law, that's a different claim. Those different claims add up to $1,000 per incident. Y'all follow me? Drop some fire in the chat if you're understanding my voice and you can comprehend what I'm saying. Because I know sometimes I talk pretty fast. I know some people just don't get consumer law at all. So I don't want to lose anybody. And because I can't see directly who's in the live and who's talking, I'm watching y'all from my MacBook. So put something in the chat. I'll know that you are um listening or that you have questions. Let me see. I did invite Facebook over here. How are you asking for it? Okay, anyway, we go back here. Okay. Anywho, um, like I said, I was coming on here just to kind of spend a little time on YouTube, see how the numbers do, see if I can go up on the algorithm or not. It's been about 20, 25 minutes. I'm going to swap over to TikTok. I'm gonna go back live on TikTok. If you guys want to see me live on TikTok, y'all go follow me, Rebecca Simone, on Facebook, TikTok, as well as Instagram. Yeah, I get it somewhat. Okay, so that's good. I'm glad you do. The more that you watch and the more that you read up on this stuff, the easier it'll get, the more it makes sense. Oh no. Yeah. All right. So that was all I have for tonight. I'm gonna let y'all go. Hopefully, you guys, this comes across y'all For You page for people who are not watching right now but are following my channel. Make sure that you drop something in the chat, that you press the like button, that you engage. So every time I drop a video or every time I go live, the algorithm does invite you to watch the live. All right. Peace and love. See you guys on the next video. I'm at.